Welcome to the intersection where technology meets compliance. I'm Pablo Fernandez Tascon, a dual qualified lawyer in Spain and the UK, and an international eDiscovery executive. Today, we're diving into a critical topic at the heart of modern legal practice: AI and data protection. Artificial intelligence is transforming the legal and business landscape. From automating due diligence to powering document review in eDiscovery. But the speed of innovation also brings a major compliance challenge: how to manage AI responsibly when processing personal data. So, how do GDPR in the European Union and the UK GDPR shape the rules? Both the EU GDPR and the UK GDPR require lawful processing of personal data. That means organizations using AI tools must justify their data use, usually under legitimate interest, consent, or contractual necessity. Whether you're operating in the EU or the UK, core principles apply: transparency, purpose limitation, data minimization, and rights of the individual, like access, correction, or objection. AI systems often process huge volumes of data and make decisions based on complex algorithms, but under GDPR and UK GDPR, individuals have the right not to be subject to solely automated decisions that significantly affect them. Think about AI tools used in hiring, credit scoring, or even in legal proceedings. This must be explainable, challengeable, and ideally subject to human oversight. And let's not forget Article 22, which restricts automated decision-making unless specific safeguards are in place. So, how can organizations make sure they follow the rules, whether you are in London, Madrid, Lisbon, Paris, or anywhere else? First, start with a data protection impact assessment, especially if your AI project could affect people's rights of privacy. This shows you're thinking ahead about risks. Next, make sure it's easy to explain how your AI works. If the system is complicated, use tools or methods that help break it down in a way people can understand. Then, keep your data use as limited as possible. Don't collect more than you really need. And always make sure there is a human in charge, especially if the AI is helping with important decisions, like hiring, legal issues, or anything else. Finally, keep clear records of how you're following the law. Regulators in both the EU and the UK may ask to see this at any time. Some businesses are still unaware that AI rules in the UK and the EU are starting to diverge. The EU AI Act, in force since August 2024, sets strict rules for high-risk AI, like hiring tools or facial recognition, and applies even to companies outside the EU if they offer AI services there. Meanwhile, the UK is taking a lighter and more flexible approach. There is no single AI law. Each regulator handles AI in its own sector. This may help innovation, but also can cause confusion. Another key difference: the EU enforces with heavy fines. The UK's Information Commissioner Officer, however, is more focused on guidance than punishment for now. Whether you are in the EU or the UK, it's essential to stay compliant and build AI people can trust. If you need help, please visit tasconlegal.com. Thanks for listening and see you next time.